Hi everyone, in this video we're going to talk about what happens to your business interest when you pass away. So this is really important to all you business owners. Depending on the type of entity you have, there are different results. So let's go through each one and talk about what happens exactly. So a lot of times people think that their business does not go to probate when they pass away. For some reason, especially in California, a lot of people just focus on their residential property or investment properties and the cash they have in the accounts. And they're worried about those two types of assets when they die and what's going to happen to them. And they think that only those assets end up in the court system. However, a business interest also ends up in probate. So if you have a corporation, for example, just because it's a corporation doesn't mean that it doesn't go to probate. If your corporation has value, it's an asset just like any other asset. So if you have a corporate interest, for example, and you don't have your corporate shares in the trust that you've already prepared, that means that at your death, there needs to be a court filing of some sort in order to bring that corporation in. So be very, very careful. All of your corporate entities, LLC entities, partnership interests, they all have an underlying owner. So a corporation is an entity, but underneath the entity, there's a person who actually owns it, right? And in a corporation, it's called a shareholder. So if the shareholder is in your name, if the shares of the stock of that corporation are simply in your name, that means when you pass away, those shares will be probatable. They will go to court. Same for an LLC. If the underlying members, which is the word we use, the fancy word we use for the owners, if the members of an LLC, so if the membership interest is just in your name individually, so if you open up your operating agreement and it says member 100% owned by Bob Smith, Bob Smith's interest in that membership is going to the probate system when Bob dies, okay? Same for partnerships, same for limited partnerships, same for sole proprietorships. Now, there are some exceptions. Usually, most business entities' interests will end up in probate unless the value of that business is very low and the person had nothing else. Then in those circumstances, we're able to wind down the corporation or wind down the business without court intervention. And the threshold amount is $188,000 and some change for this coming year in California. So let's say Bob Smith has a corporation and it's worth absolutely nothing. There's $2,000 in that corporate account. The corporation doesn't have any assets of any sort. It doesn't have furnishings that could be sold. It doesn't have any accounts receivable that could be sold or client lists or whatnot. It's literally worth nothing now that Bob is gone, except for the bank account. Well, and Bob has nothing else, no other assets that are going through probate. If the value of that corporate share is less than $188,000 and some change, then we're able to close down that business without the need to actually get court approval. So be very, very careful when you're dealing with your corporate interests. Make sure if you already have a trust in place, make sure that your corporate interest, your LLC interest, your partnership interest, make sure that your ownership rights in that company are actually in the name of your trust, not you individually. If they're in your name individually, they are subject to probate in California, so be very careful. As always, we welcome you to consult with our law firm if you have questions. If you have a trust in place and you need it reviewed, we also welcome you to reach out to us. We can assist you with the review process as well as a transfer of your corporate shares or LLC interests into your trust, and we welcome your call. Have a good one.